Now we're looking at a big decision now that's come by the Karnataka High Court, a verdict that was pronounced, which it appears educational institutions across Karnataka will have to follow. Remember, this comes as almost a benchmark verdict. What the Karnataka High Court has pronounced will be benchmark to all those courts in the future, including the Supreme Court, while if at all it deliberates on the matter, as petitioners now seek Supreme Court intervention. This is what we hear. But this is almost a landmark verdict for several other states, if in case a situation like this arises, not just with the hijab or in fact any other kind of religious symbol, if at all students push to wear inside their classrooms, this will be almost a referral verdict. Verdict that will, of course, resonate across India if a situation unfolds in different parts of the country. In Karnataka itself, it has come as a massive debate on whether or not this right to profess their choice of religion is allowed inside classroom, or is that right, which comes under the Constitution, is left only outside educational institutions. Now the court saying that CDC itself, remember, there were petitioners, in fact, the counsel of those petitioners constantly questioning and asking whether the CDC, which is the College Development Authority, the College Development Council, really had legal sanctity to frame guidelines that in fact, rejected students from following their religious practice inside classroom, that really pushed students to shed their religious practice right outside college campus, whether the CDC itself had legal sanctity. Now, almost indirectly, with the Karnataka High Court's verdict here, it comes very clear that the CDC itself has absolute validity as it comes under the Karnataka government. It has absolute validity and sanctity to issue guidelines and frame guidelines according to their definition of uniformity. So all that argument whether CDC had any authority to define uniformity, yes, the Karnataka High Court's verdict almost declaring that the CDC, which comes inevitably under the Karnataka government, has all the right to frame guidelines in college institutions and students cannot oppose it. Remember, we have reactions coming in all across. Let me cut across that. But Anisha Mathur, for a little more perspective on the court's verdict here. Anisha, this is really going to be a landmark judgment, almost a benchmark for several other states, if in case a situation arises anywhere in India next. Because soon after the hijab controversy, we saw protests in different pockets of the country, including Kolkata, Chennai, Kerala. We also saw it in Delhi. This is going to have repercussions in the days to come, if anything. The matter might go to the Supreme Court, but how does this really, what kind of message is this verdict really sending out as of today?
Well, we'll have to see the verdict in its entirety. Look at it this way. It's a 129-page verdict which is looking into various issues. One of whether wearing of hijab is essential practice or not. The court has categorically looked into the various teachings of Islam. It has looked into various religious texts, and it has looked into the submissions made by the lawyers, and has said that the wearing of hijab is not, in fact, an essential religious practice. That itself is going to have serious repercussions when it comes to interpretation of the entire controversy when any other court or any other state government will look into it. Secondly, they have said very clearly that the prescription of a uniform is in fact a reasonable restriction that the government could have done, and there is nothing wrong with prescribing a uniform, and people have to follow the uniform that has been prescribed. So that is also something that could have ramifications if such kind of controversy is raised in any other states as well. Now, what is also interesting is what they have said about these college development committees. They have said that the schools, and I'm quoting this here, there is no legal bar for the school betterment development committees to associate with the process of such prescription. However, there may be some scope for the view that it is not desirable to have elected representatives of the people in the school committees and possible infusion of party politics in the campus. And there they have, while this is not part of the operative portion of the judgment, of course, because the court has very clearly said that the uniform prescribed is correct, but the observations that the court has made with regard to the political participation in the management of the colleges and the college development committees, this is something that will that could lead to discussion outside of this particular case as well, that how far are we allowing political considerations to come up when it comes to our education system. But all in all, the basic point of this judgment has been that since hijab is not part of the essential religious practice, that it is in fact not followed in large parts of the country, and it is also, they've also in fact looked at other countries as well. If you see the conclusion of the judgment as such, they have said that they've also gotten into the issue of PIL jurisdiction. They've also gone into this controversy regarding the political considerations regarding Islamization. That is something that one of the petitioners had said that the government has every right, and there is a particular sort of religious fanaticism that is being brought in. The court has said all of this is completely unnecessary, that we're not going into the police investigation, we're not going into the issue of social unrest and disharmony. In fact, they have clearly said that the issue, we are dismayed that in the middle of the academic term, in the middle of nowhere, this controversy of hijab was generated and then blown out of proportion. And it gives scope to the argument that some unseen hands could be at work. So very, very important comments made by the court here in its verdict. But all in all, the question is that there should now be a quietus, but the petitioners have very clearly said they will be going to the Supreme Court to file an appeal. So these points are going to be very important, where the court has said that there could be some outside political implications of this controversy, that this kind of thing came up suddenly in the middle of the academic year and was blown out of proportion. We'll have to wait and see how...
Anisha, like you rightly said, many of those, and I'd like to reiterate it again, Karnataka High Court's verdict will only now push many of those institutions that earlier never banned hijab now to ban it and phrase a new set of guidelines, or almost impose the existing guidelines and try to elaborate it and elaborate exactly what uniformity really means, which means many students who were earlier allowed to wear hijab inside classrooms might be restricted now. Do you think that this will have another valid point of argument in court? Will this hold good? A commotion like this, will that be something that the court, including the Supreme Court, would want to take up at the earliest, considering students may be deprived of their education for the only reason because many Muslim families, as much as we know on ground, do not allow their girls to go to schools or colleges without wearing the hijab. It means that they might just even drop out in large numbers.
But Nabila, that is not something that the court can look into. That is a social issue. That is an issue that the government, that the religious leaders, that the community leaders, that the families will have to deal with. The court will be dealing with whether the Karnataka High Court verdict is correct or not.
All right. Anisha, I'm going to cut you short right here. I'm going to quickly cut across to Prabhuling Nawadgi, Advocate General in Karnataka, joining us live here. Prabhuling, thank you very much. Appreciate your time. Here is the Karnataka High Court verdict that very clearly states hijab is not an essential practice in Islam and that students cannot resist or refuse uniformity prescribed by the college authorities under the state government's leadership. How do you look at this verdict?
I'll take it.
Prabhuling.
Okay.
All right, we have the Advocate General himself who's argued there on behalf of the Karnataka government. Prabhuling, the Karnataka High Court's verdict here states hijab is not an essential religious practice. Give us the sense of what the arguments were that led to this decision. Prabhu, can you hear us? Prabhu, can you hear us?
Yes, please. Yes, please. Who's... Okay. Yes, please. Go ahead.
Prabhu, our question here, Karnataka High Court's verdict very clearly stating that hijab is not an essential religious practice and therefore students cannot resist uniformity prescribed by the institutions. How do you really look at this verdict and what were the arguments that really led for the court to uphold the Karnataka government's decision and their definition on uniformity?
Yes. If you could see, initially when the petition was presented, they said that we have a right to wear a dress of our choice. And that was resisted, saying that institutional discipline will prevail over individual choice. But then in the second round, the argument was raised by filing other petitions saying that since it forms part of essential religious practice and under Article 25 of Fundamental Right, therefore the question of under the Karnataka Education Act, an institution or the government prescribing a school dress does not arise, because fundamental right obviously is higher to any statutory right. It is in that context the High Court was called upon to answer both the questions. Question number one was whether it forms part of essential religious practice. And while answering that, the court has relied upon the principles evolved by the Supreme Court in Shabarimala, 4 or 5 principles, and has upheld that there was no evidence produced by the petitioners to hold that it formed part of ERP, and thereby denying that it was formed a part of a fundamental right. Secondly, it has held, once that is established, then the insistence of a particular school dress by every educational institution should be considered reasonable restriction, and thereby the principle of institutional discipline prevailing over individual choice has been upheld.
So from what you say, it is the college discipline that is paramount, that will surpass any religious practice as well. As of now, since hijab is not an essential religious practice, as per declared by the Karnataka High Court, it appears that college disciplinary committee and their guidelines is going to be held as paramount. That's going to be the order. There were a lot of arguments.
It ought to be. I'm sure everybody would agree. I'm sure everybody would agree with that. That individual choices would result in chaos. Therefore, institutional discipline must prevail.
But it also comes under fundamental right to profess one's religion. How has that been argued in court there?
That's the question. That was the fundamental question, whether it formed part of right to religion. But every practice does not form part of religion. A religion has many aspects, moors. What the Supreme Court has held is, every practice does not form part of religion, but it is only those essential practices which form part of religion. If in order to prove it's an essential practice, you have to undergo rigorous tests which the Supreme Court has laid down. And I must say, petitioners had failed in each and every test prescribed by the Supreme Court.
Now, we believe that petitioners are exploring legal avenues. They probably will approach the Supreme Court. Are you following and tracking those developments, sir?
No, I'm not following anything, but as and when if the matter goes to the Supreme Court, we'll respond.
Do you believe the arguments will hold good there at all?
Most certainly. Judgments, the issues which we had raised and answered were based on the judgments of the Supreme Court and sound legal principles. We are very confident. Thank you so much.
Right. Thank you very much, Mr. Prabhu, for joining us. That was the Advocate General joining us, who's argued for the state of Karnataka. Karnataka government has been constantly harping on the fact that uniformity must be maintained. And it's not a new law. That's what the Karnataka government says. B.C. Nagesh joining me right here, Education Minister, who's been right from day one telling us exactly the same, that the Karnataka government is not against hijab as a practice at all. It's one's wish to wear what they want, where they want to. But when it comes to educational institutions like classrooms, there must be uniformity that must be maintained. Those institutions that have CDC guidelines, that have strict guidelines when it comes to uniformity, you cannot veto it, and there must be no argument on that. Mr. B.C. Nagesh, it appears your government's vision and your definition of uniformity inside classrooms has almost been upheld by the Karnataka High Court with its verdict being pronounced. How do you look at this?
Definitely, I am very happy because the High Court has upheld the stand of the government, and it has upheld the Karnataka Education Act and the rules of 1995. Whatever the petitioner had questioned has been dismissed, and lawmakers who had prescribed uniform to create uniformity among the young mind of India has been upheld. We know that the complexity will not be developed everyone feels equal before the law, and everyone feels that we are the sons of the great motherland. So uniform was introduced well before BJP government came in Karnataka. And that was upheld by the Honorable Chief Justice of the Karnataka High Court. I welcome the judgment.
Right. Mr. B.C. Nagesh, we heard you yourself are appealing to educational institutions to uphold the Karnataka High Court's verdict. But what we know of and what we saw right after the interim order came was many institutions that earlier allowed hijab went back to ban it completely. Would you have any word of advice to those institutions that earlier allowed hijab? Post this verdict, what should they follow?
Because I think you have followed the interim order. In the interim order, the judge had clearly said that neither orange shawls, nor flags, nor hijab can be allowed into the education institution. That is how, because of this, all the institutions followed the instruction given in the interim order of the judgment.
Right, but the interim order very specifically said that only institutions with CDC guidelines must maintain status quo. Others don't come under that ambit. But we saw almost a fallout and repercussions with other institutions that earlier allowed, now not allowing. Again, a word of direction from your end will really help solve the commotion and confusion outside these institutions, sir.
No, whatever the confusion which had come earlier will be clarified in future rules and acts. We are going to observe whatever the observation made by the Honorable High Court, and we'll study the final order copy, final orders after receiving the order copy. We'll speak with the Honorable our Chief Minister, and also with the legal department, and we will try to see that all loose end in the rules and act will be set right.
Like, for example, Mr. B.C. Nagesh, a quick word, like minority educational institutions which earlier allowed Muslim girls to wear hijab, even those minority schools and colleges had like a blanket ban waiting for the verdict. A word of advice to them.
As I said, I am going to, after receiving the order copy from the High Court, we are going to study that, and then we will finally say. But as of now, no government institution has right to allow hijab,
including minority institutions.
Yeah, if it is a government institution, definitely it cannot.
But it is a minority institution. It caters to the Muslim community.
No, but rules has been framed by the government of Karnataka. It runs the school institutions.
All right. Mr. Nagesh, when we speak of uniformity...
Because uniform has been...
Go on, sir.
I did not hear you properly.
No, go on. I said it is a minority institution. It is a Muslim institution run by the government. There too, it's not going to be allowed. Is that your stance? There are two types of educational institutions. One is deemed institutions, and we are run by the private peoples, and there are some minority institutions run by the government. Right.
In the all minority government institution, percentage of the has been fixed. Even 20 to 30% of the other students will be allowed in that institutions.
All right, Mr. B.C. Nagesh, a quick word.
The
Karnataka government's decision on uniformity. All right. There you have B.C. Nagesh there, Karnataka Primary and Secondary Education Minister, who's been maintaining right from the start to date that uniformity must be maintained. There must be no discrimination. At least the college, the students should not feel different inside a classroom, and therefore no religious symbol will be entertained. It should not be entertained. And rightly for them, the Karnataka High Court's verdict now has pronounced that no students can oppose uniformity set by the CDC, the college administration, under the leadership of the government, and that hijab itself, on the debate of whether it is an essential religious practice or not, well, the Karnataka High Court very clearly saying it is not an essential religious practice. I'm going to slip into a short break. India Today's coverage on this issue continues on the other side. Do stay with us.